Good morning. Welcome again to our webinar. Today's topic, a follow-up from yesterday's topic. We had many questions yesterday, and after the webinar, we had some more questions which I had a look at, but I could not answer. And hopefully we can elaborate upon that again. If you have any live questions, as we had yesterday, feel free to pose it, and obviously I'll try my best to answer it for you. You have to post it on the Advocate Mohammed Abduroaf Facebook page. If you post it on any other page, I'll see it later on, but obviously I would not be able to answer it and engage with you with regard to that. Nonetheless, today's theme would be a bit different. I'll focus on the issue concerning child custody, child maintenance, and divorce, but from a different angle, dealing with third parties, non-parents. I can't deal necessarily with that in relation to divorce. However, I can deal with that regarding child custody. For example, can an uncle have child custody, an aunt, a grandmother, stuff like that. Child maintenance. May you claim maintenance from grandparents, from uncles and aunts, and so on. So that will be the angle from where we will deal with that. And with regard to divorce, a different angle would be, what do you do if you cannot find the spouse to get divorced? You guys are married, however, separated, your spouse went missing, and now you want to get divorced. So it's a bit of a different flavor regarding that. If you want more information regarding this topic, please watch our video of yesterday. If you are watching it from Facebook, it should be on all our pages. If you are watching it from YouTube, it should be the previous video that would have been posted just before this one. Nonetheless, let us begin with this interesting topic, and I'll be keeping an eye on the Facebook page for any questions that you may have and which you would like me to answer live. And that's the only way I can answer them. On the issue concerning child custody. Now, in South African law, only mothers and fathers can have parental rights and responsibilities by default. When a child is born, grandmother has no rights, grandfather has no rights, aunt and uncle have no rights to the minor child. If the parents decides to move overseas or move away or not allow any of the parents or siblings or their siblings to have any contact with the minor child, that is it. Unfortunately, you as uncles, aunts, grandparents have no default rights to a minor child. And in the same way, by default, you have no responsibility towards that child, for example, paying child maintenance and so on. There might be a social responsibility, a cultural or religious responsibility, but from South African legal perspective, there is no obligation. The parents are responsible for that. That's a default situation. That's the point of reference. However, when dealing with matters concerning children, in child custody matters, we focus on what is in the minor child's best interest all the time. If a third party, let's say an aunt, cares for a minor child, and the parents are unable to care for the minor child, and the aunt looks after the minor child, rears the minor child, and now a few years later, the parents clean up the act and they decide, no, we're taking the child back and we're continuing caring for the minor child. That is good and well. I'm happy for that. However, now the parents decide, we had a bit of a fallout with the aunt. The aunt still keeps telling us how to care for these minor kids because she looked after them for 5 years. And we're cutting ourselves from this aunt, or from my sister or the child's aunt. What happens then? Must the aunt accept it? If the aunt wants to accept that situation, that is fine. Nothing will happen after that. Or the aunt can say, you know what, I think I want to remain in the minor children's lives, continue forming part of their lives. And if the aunt makes such a decision, the aunt can approach the court. And the court can apply its mind to the situation. And if the court believes it will be in the minor child's best interest for this aunt, this third party, to acquire parental rights and responsibilities over the child, for example, have rights to have contact with the child on a regular basis, whereby the minor child might overnight by the aunt's home every second weekend, meaning the parents would not have any actual physical contact with the minor child for those 4 days in the month, every second weekend. Then the court would make such an order because it would be in the minor child's best interest. And under these facts and circumstances, if the aunt cared for the minor child for 4 or 5 years, the minor child at some point believed the aunt was her mother or their mother or his mother, and the minor child misses his aunt and wants to see this aunt because the parents were missing. The child now knows, okay, this is my mom and dad, but you were not my mom and dad for the last 4 years. You can approach the court, and the court can apply its mind to the matter, listening to what the father has to say, the biological father, biological mother, listening to what the aunt has to say. Maybe there's an expert on board, the school teacher, family advocate's office, psychologist, counselor. See what all they have to say, and if it concludes that it is in the minor child's best interest for this third party and aunt to acquire parental rights, the court will make such an order. These third parties could be anyone. Could be a grandmother, a grandfather, could possibly be a very older sibling, that's also possible, or totally third parties, people that just cared for the minor child. That is not a problem. Obviously, the court will look at all the circumstances and all the facts. I do not for one believe that if a minor child was cared for by certain persons for quite a long period of time, and now the parents decide to take back the minor child, that it would be in the minor child's best interest not to have any contact with those specific persons. That would not be in the minor child's best interest. In my view, if all else is equal, obviously, I can think of a scenario, which is my job, where it will not be in a minor child's best interest. But generally, should it be a normal situation, it would be in the minor child's best interest for this third party to have care and contact to the minor child. So that's a spin where I'm dealing with child custody from a different angle, where you focus on what is a minor child's best interest. Regarding child maintenance, we have discussed in our previous video yesterday how child maintenance is calculated. We dealt with a few scenarios, etc. But let's take it from a different spin. Let's say, for argument's sake, the parents themselves cannot afford to pay the child maintenance or to maintain the child financially. Let's say the mother earns a small amount of money and the child lives with the mom. The father, unfortunately, cannot be found, or the father cannot afford. He's a student or he's working, but he's earning very little money. But the child requires a lot of money. Not a lot, but more than what the parents can afford. The mother's parents, they are around, but they are pensioners and they also have limited monies. But the father's parents are quite wealthy. They have money. And they can afford to maintain this minor child because the father cannot maintain the minor child at all. Under those circumstances, it is possible to approach the maintenance courts, and the courts would look at all the circumstances, all the facts of the matter, calling the parents, the paternal grandparents, maybe calling the maternal grandparents as well, to verify that they cannot afford to also contribute. And the court would make a fair decision, and the court may order that the paternal grandparents of the child, despite the parents not having been married to each other, that the paternal grandparents should maintain the minor child, should pay some form of maintenance in order for the minor child to be able to live. For example, the child was fine, the child was quite young, and the mother could survive with her money to care for the child, but now the child has to go to daycare, or the minor child has to go to creche, or aftercare, whatever the case may be, or to school. And those are quite expensive. Child requires school clothing, etc. And now the mother requires more money. Father cannot afford it. His parents can afford it. If her parents can afford it, wonderful. She can approach the court to enforce them as well. But generally, the mother's parents would give their contribution, whatever it may be. So that's the one spin on child maintenance. The other spin, or the other issue that may arise, is that one parent, or at least a parent who has to pay child maintenance, no longer lives in South Africa, lives overseas, lives abroad. And now you would like to claim maintenance from that specific parent. Obviously, our courts have only jurisdiction over people living within the area of the jurisdiction, basically South Africa, or the Magistrates Court jurisdiction, or the High Court's jurisdiction, and so on. For example, the High Court in Cape Town would have it over the Western Cape. The Magistrates Court in Cape Town would have it over the Cape Town area, and so on. Johannesburg, KwaZulu-Natal, etc. That same principle applies. But a judge in Cape Town cannot direct an officer in the United States. Officer, do this. Force other party to pay maintenance, and so on. That's not how it works. We do not have power over other countries. And the same way, they do not have power over our citizens. There are, however, international agreements, treaties that have been signed between countries to sort out these issues. One would be, for example, the Hague Convention on Child Abductions. That's not a full term, it's quite a long term. But nonetheless, if one parent removes the child from South Africa, takes the child to a different country to other consent of the other parent, that's seen as child abduction, and you can apply international legal principles, and following certain diplomatic channels, the minor child could have to be returned to South Africa. So we work with the governments are working together regarding that. But nonetheless, we're discussing child maintenance. There is an act called, a piece of legislation called the Reciprocal Enforcement of Maintenance Orders Act, South African piece of legislation dealing with the reciprocal enforcement, meaning reciprocal. South Africa has an agreement with America, for argument's sake, and they will assist each other in enforcing whatever maintenance orders that are in place in the Pacific countries. I am seeing certain questions. Thank you very much for that, and I will deal with that shortly after I've explained the scenario. So we have an agreement with the United States. Certain states in the United States, South Africa has an agreement with them, whereby if the person who has to pay maintenance lives in the United States, a complaint will be made locally in South Africa, in the South African Maintenance Court. You will outline that you are the parent, the child is living with you, these are your expenditure, this is the father, he lives overseas, in my example here, and there'll be an inquiry, and the court in South Africa will come to a determination, okay, under these circumstances, the child costs X amount of money, and the mother can afford so much, and we think a reasonable amount of maintenance would be X. They would send that documentation via diplomatic channels to the state in America, to their Pacific Maintenance Court, whatever they have that side, and that maintenance court will get hold of the father, call him in, and then do an inquiry that side. And they will come to an amount, and that specific amount would be made an order of court in the United States, and obviously that details will be sent down to South Africa via diplomatic channels. So the opposite also applies. If this person who has to pay maintenance lives in South Africa, the authorities in the United States will send that specific order, maybe that's a provisional order to South Africa. We will call in the other party, look in the matter, come to a decision, and obviously make an order and send the order down to the United States. So this is reciprocal enforcement of the maintenance orders. So that's something interesting where that is concerned. We have some questions. Wonderful. Let us deal with that. We copy it in quickly. This will be question live. Question 1. Thank you for that. That's the first question. I see there's a follow-up on that specific question. Same person. Let us deal with that. Let me copy that in as well. Okay, so I will definitely deal with that question. Thank you for that. But before I deal with the question, let me just finish the topic on child custody, child maintenance, and divorce. So the next theme from a different spin would be divorce. As I mentioned earlier on, please watch yesterday's video, some more details regarding this topic. Let us say the parties, they are married, and one party cannot be found, but the party remaining in South Africa wants to get divorced, or he knows where the other party is, but unfortunately cannot serve the documentation on them. So remember, this is how South African law works. In order for a divorce to take place, divorce documentation needs to be served on the other party, and in South Africa. If you want documentation to be served upon the other party in a different country, we do not have sheriffs there. So we have a sheriff in South Africa, South African Board of Sheriffs, a member of them, and he knows his job. He knows how South African law works, and he knows how to serve summonses and documentation upon the other party. The United States, the UK, China, Finland, New Zealand, Australia, they have their own processes applicable over there. So we do not direct sheriffs that side to serve documentation. However, the parties want to get divorced. Under certain circumstances, if you cannot get hold of the party or you know the party is overseas, let us deal with the overseas part. You approach your court locally and advise the court. I've issued divorce summons, but the other party lives in the United States. I only have an email address where this party is concerned. I do not have anything else, but the email address works. Can this documentation be served upon him via email? You will explain that to the court, and the court will say, you know what? I think this is the only way you can proceed with this matter. I hereby give you leave to serve the summons upon the other party via email. And by to get the order, the attorney would obviously email the other party the summons, for scanning the summons, the email to the other party. And if the other party does nothing within 10 days, obviously the divorce can proceed on an unopposed basis. And should it proceed on an unopposed basis, the judge will look at the file. The judge will say, I don't see a return of service, but I see, okay, there's an order that was granted previously stipulating that the summons can be served upon the other party by email. Oh, I see an affidavit here from an attorney stipulating that the summons was served upon the other party by email. The judge will be happy, and at least that requirement would have been met. The court would be convinced that you informed the other party about the divorce. If the other party done nothing about the matter, too bad. Wonderful, life goes on. But if the other party decides to oppose the matter, it proceeds as any opposed divorce matter. Okay, that was that was the 3 topics: child maintenance, child custody, and divorce. I have another question. Let me deal with that quickly. Copy and paste it. And that's it. If there are any other questions, I would like to deal with that as well. Question number 1. Can in-laws, the grandparents or aunt, force themselves to minor children that does not know them at all? Will the emotional not be in the best interest? Okay, I get the gist of the question. No, they cannot. They have no parental rights at all, so they cannot do that. It's your job as a parent to protect the child from any third parties. Obviously, as families, certain issues involved, complications involved, and so on. But in principle, they have no right. And for me to be blunt, if they are consistently imposing themselves, you can approach the court and get a protection order against them. Obviously, you try to avoid all of that. I only have 2 lines of question here. I'm giving you a general answer. Try to mediate, try to resolve these issues. But if someone persists, because a person does not have a right to the minor children, you can approach the domestic violence court and get a protection order against them. But ultimately, my answer is no, they do not have a right. Let's deal with the second question. Question number 2, live question. Can a judge grant a divorce if the other party does not want to sign the paperwork? There is no obligation upon the other party to sign the paperwork. The paperwork is what you want. So let's say you want to have custody and the other party wants to have custody. So there's no obligation upon him to agree to that. Ultimately, the court would have to make a decision here, evidence. So if a divorce wants to be resolved quickly, you get the party to sign documentation, so the divorce is resolved, and there's no need for us to run a full-blown trial, call witnesses, and put people on the witness stand and argue at the end of the court case. That's not necessary because the divorce has been resolved. If the divorce has not been resolved, they're not willing to sign any documentation or to agree upon anything, fine. The matter must proceed as normal. The same way, for example, can a criminal charge, if somebody charging you for theft, can that go ahead without you admitting to guilt? Yes. You say you're innocent and the proceedings must go ahead. The same way with a divorce. The party says, I'm not willing to sign it. Perfectly fine. You follow the proceedings, discovery, providing whatever documentation the other party wants. Make sure the matter is still ready. Get a date for the judge. Go on the witness stand. Prove your case. The other party will do exactly the same. At the end of the day, the court will make a decision. So regarding your question, yes, you can proceed. It will obviously take a bit longer as the case should the parties come to an agreement regarding the divorce. I think that is it for today. I see no other questions that are being posed. There's no one else that has any live questions. Thank you very much for your questions and for your time for watching this video. And I hope to see you online again soon. Have a lovely day.